Have you ever wondered what happens when an ordinary veteran, already fighting an unseen war inside their own body, decides to take on the monolithic, labyrinthine bureaucracy of the Department of Veterans Affairs, and actually, stunningly, wins a victory so profound, so legally significant, that the very agency they defeated tries desperately to sweep the entire record under the rug? This isn't just a tale of successful claim. This is the story of a procedural earthquake, a case that exposed the systemic flaws designed not just to deny claims, but to make the very act of appeal so exhausting, so psychologically devastating, that most veterans simply give up long before they reach the finish line. We're talking about a landmark decision, one that the VA, specifically certain elements within the Veterans Benefits Administration and the Office of General Counsel, have been actively trying to suppress, attempting to minimize its impact on future appeals, effectively hoping that you, the veteran who needs this precedent the most, never hear about it. But we're going to pull back the curtain on this classified success, detailing every denial, every appeal, every strategic maneuver that led to the VA's humiliating but ultimately necessary surrender. The entire saga began, as so many do, with the setup, the initial denial, and the veteran's critical mistake. Our veteran, let's call him Sergeant M., filed his initial claim for a complex, debilitating service-connected condition. This wasn't a simple knee injury or hearing loss. This was a condition with delayed onset, often masked by other symptoms, making the connection, the crucial nexus, difficult to establish years after separation. Sergeant M., like countless veterans before him, made a fundamental, almost universal, mistake in his initial filing. He relied entirely on the VA's supposed duty to assist. He believed that if the evidence existed somewhere within the vast government archives, whether in his service treatment records, STRs, his C-file, or even in the records of a military hospital across the globe, that the VA would dutifully locate it, piece it together, and establish the connection. This foundational trust, this belief in the system's good faith, was precisely what the system was designed to exploit. The VA, in its initial rating decision, RD, issued a swift, boilerplate denial. The language was cold, clinical, and devastatingly vague. Service connection is denied because the evidence does not show a direct or secondary relationship between the claimed disability and service. They cited a lack of continuity of symptoms, a lack of documentation during the relevant time period, and dismissed the private medical opinions M submitted as less persuasive than the VA examiner's brief, often hostile, negative opinion. This denial, delivered with bureaucratic precision, served its primary purpose: to demoralize. Sergeant M was told, in essence, that his suffering was unsubstantiated, that his memory was unreliable, and that his doctors were misinformed. The VA had successfully deployed the first layer of resistance, relying on the veteran's ignorance of the procedural requirements, specifically the need for a highly detailed, legally defensible medical nexus opinion, often called a more likely than not statement, which must explicitly rebut the VA's own findings. The veteran's critical mistake wasn't a lack of evidence, but a failure to present that evidence in the exact, rigid format demanded by the 38 Code of Federal Regulations, CFR, and the manuals, a failure the VA relies upon to clear the docket of claims that require actual investigative effort. They counted on him accepting the denial, perhaps filing a supplemental claim with the same insufficient evidence, leading to an endless cycle of frustration known informally among advocates as the hamster wheel of denial, where the veteran spins their wheels for years, never gathering the necessary legal ammunition to breach the VA's defenses. The initial denial was a strategic victory for the VA, not based on medical fact, but on procedural attrition. But Sergeant M didn't stop. He was tenacious, and this tenacity led to the discovery of the hidden evidence, what the VA knew but didn't disclose. This is where the story pivots from procedural error to actual bureaucratic malfeasance. during the initial appeal process, specifically when transitioning from the legacy system to the Appeals Modernization Act (AMA) framework, a confusing shift the VA often uses to bury old evidence. Sergeant M's legal team requested a complete, unredacted copy of his C file, claims file. Now, the C file is supposed to be the comprehensive repository of every document related to the veteran's service and claims history. What they received initially was the standard sanitized version. However, a meticulous cross-reference of the index revealed discrepancies. Specifically, there were references to internal memoranda and quality review notes dating back to the year of his separation that were entirely absent from the delivered file. These weren't standard forms. These were notes generated by the Military Medical Command shortly after M's discharge, discussing his post-service health trajectory and making specific recommendations for long-term care. Recommendations that strongly implied a service connection, even if the formal diagnosis hadn't been codified yet. The VA had a legal duty to disclose all relevant evidence, both favorable and unfavorable, under the de novo review principle. Yet these documents, which were clearly favorable and directly contradicted the initial denial's claim of lack of continuity, were deliberately withheld. How was this possible? The investigation revealed that these specific documents had been flagged internally by a regional office, RO, quality reviewer years earlier, not because they were irrelevant, but because they contained language that, if publicly available, would set a dangerous precedent for connecting delayed onset conditions. The documents essentially admitted institutional knowledge of the long-term risk factors M faced due to specific service exposures. The VA wasn't just denying the claim based on lack of evidence. They were denying the claim while actively possessing evidence that proved the claim. This constitutes a profound breach of the duty to assist and raises serious questions about the ethical conduct within the RO. The discovery of this hidden evidence fundamentally shifted the nature of the appeal. It stopped being a fight over medical nexus and became a fight over procedural integrity and the suppression of truth. The legal team immediately filed a motion alleging clear and unmistakable error, CUE, in the initial rating decision, arguing that the decision was based on an incomplete record, a record deliberately curated by the VA itself to favor denial. This maneuver forced the VA to confront the existence of the documents, leading to a frantic, behind-the-scenes effort to justify their omission, utilizing obscure regulations regarding internal working documents and pre-decisional communications, arguments that ultimately failed to withstand scrutiny because the documents were factual records of medical assessment, not simply internal deliberation. The VA's attempt to hide these records was the first clear sign that they viewed this case as a threat, not just an administrative burden. The sheer volume of internal email traffic later uncovered, discussing the sensitive nature of these records and how to manage their discovery, painted a picture of calculated obfuscation, a systemic effort to protect the VA's financial liability by concealing favorable facts. With the hidden documents now forcing the VA's hand, Sergeant M's team implemented the strategy shift, why the traditional appeal path failed. Initially, M had pursued the traditional higher-level review, HLR path under the AMA, hoping a fresh set of eyes would catch the error. This path failed, miserably, confirming the team's suspicion that the denial was institutional, not accidental. The HLR reviewer, constrained by the existing record, which still lacked the hidden evidence, simply affirmed the prior denial, stating that the preponderance of the evidence remains against service connection. This is the point where most veterans abandon the fight, seeing the HLR as the final definitive word. But M's team realized that the HLR process, while faster, was inherently limited. It only reviews the evidence already in the file, and cannot accept new evidence or compel the VA to produce documents they are actively suppressing. They needed a forum with greater investigative power. They abandoned the HLR lane and pivoted to the Notice of Disagreement, NOD, leading directly to the Board of Veterans' Appeals, BVA, specifically choosing the evidence submission lane, which allowed them to introduce the newly discovered internal memoranda and accompanying expert testimony. This strategic pivot was crucial. The BVA operates under a different legal standard and is more willing to scrutinize systemic procedural failures than an RO or HLR reviewer. Furthermore, they realized they couldn't just submit the hidden documents. They had to frame them legally. The traditional approach, simply arguing the medical connection, was insufficient. The new strategy focused on two prongs. First, a legal argument proving the VA's breach of the duty to assist and the concealment of evidence, making the original RD void ab initio from the beginning. And second, a highly specialized independent medical opinion, IMO, that didn't just state the nexus existed, but explicitly referenced the hidden internal memoranda as foundational proof of the military's knowledge of the condition's origin. This IMO was crafted by a physician specializing in the specific environmental exposures M experienced, tying the internal VA documents from 30 years ago directly to the current diagnosis. This strategic shift from a purely medical appeal to a combined medical procedural challenge transformed the case from a routine denial into a landmark legal challenge, forcing the VA's lawyers to defend not just the medical opinion, but the integrity of their entire claims processing system. This change in focus meant the VA could no longer hide behind medical uncertainty. They now had to explain why they intentionally failed to disclose critical information, a much harder argument to win at the BVA. The decision to bypass the bureaucratic quicksand of the supplemental claim route, which often leads to endless remands, and go straight to the BVA with a fully developed legal theory, was the turning point that put the VA on the defensive. The moment the BVA docketed the appeal, the VA erected the bureaucratic wall, the specific tactics used to delay the case. Recognizing the danger posed by the hidden evidence and the procedural QU argument, the VA's legal team initiated a campaign of administrative friction. Their goal was simple: delay the BVA hearing long enough for Sergeant M, who was elderly and medically fragile, to potentially pass away, effectively extinguishing the claim and preventing the establishment of the damaging precedent. This is a cold, hard truth of high-stakes VA appeals. Time is the VA's greatest weapon. The tactics were sophisticated and relentless. First, there was the request for clarification barrage. The VA lawyer assigned to the case filed multiple, lengthy requests for clarification on the CUE argument, not because the argument was unclear, but to force M's team to spend weeks drafting detailed legal briefs, answering questions that had already been addressed in the initial filing. Each clarification request triggered a mandatory pause in the BVA's review timeline. Second, they employed the supplemental examination loop. Despite the robust IMO provided by M's team, the VA insisted on ordering multiple redundant compensation and pension (C&P) exams, claiming the record was still inadequate. These exams were often scheduled in locations inconvenient for M, utilized examiners unfamiliar with the specific condition, and inevitably resulted in negative opinions that contradicted the independent medical evidence. Each new C&P exam required the BVA to halt proceedings, review the new evidence, and gave the VA lawyers fresh ammunition for further delay, arguing that the case needed further development rather than a final decision. Third, they utilized the jurisdictional dispute gambit. The VA attempted to argue that the BVA lacked jurisdiction to hear the CUE argument because the initial denial predated the AMA, a convoluted and ultimately baseless legal maneuver designed to waste judicial resources. This required M's team to file a detailed rebuttal brief citing specific statutory and case law precedents, consuming precious months. The cumulative effect of these tactics was staggering. The appeal, which should have taken 12-18 months under the AMA, stretched into nearly 3 years. Sergeant M's team fought every delay aggressively, filing motions to compel, motions for expedited review, and detailed objections to the VA's frivolous requests. They understood that the VA wasn't fighting the claim, they were fighting the clock. This protracted battle exposed the VA's willingness to weaponize procedural complexity to protect institutional interests, often at the direct expense of the veteran's health and well-being. The sheer cost, emotional and financial, of navigating this bureaucratic minefield is precisely why the VA wins most of these long-term fights by default. But Sergeant M held firm, driven by the knowledge that his victory would open the door for thousands of others facing similar denials based on suppressed information. The VA's delay tactics were a clear admission of fear. They knew they couldn't win on the merits, so they tried to win on exhaustion. The turning point, the moment the bureaucratic wall began to crumble, arrived with the game changer, the expert testimony that couldn't be dismissed. Sergeant M's legal strategy culminated in a virtual hearing before a BVA Veterans Law Judge, VLJ. The centerpiece of their presentation was not M's own testimony about his suffering, though that was emotionally powerful, but the testimony of the independent medical expert, Dr. R. Dr. R. was not just an expert in the medical condition. He was an expert in the historical military context of the exposure M endured. The VA's previous denials had always hinged on the idea that the condition was idiopathic, of unknown origin, or unrelated to service. Dr. R. meticulously deconstructed this argument. He didn't just offer an opinion. He provided a comprehensive medical narrative that integrated the newly discovered internal VA memoranda. He testified that the VA's own documents from 1995, which detailed M's early post-service health issues, constituted a form of institutional recognition of the risk. Dr. R. used highly technical, peer-reviewed literature to establish a biological plausibility, showing the specific mechanisms by which the service exposure led to the delayed onset of the condition. Crucially, he didn't just state his opinion, he explicitly addressed and rebutted every single point raised in the negative VA C&P exams, dissecting the methodology and factual basis of the VA examiner's findings. He highlighted where the VA examiners failed to review the complete file, where they misapplied diagnostic criteria, and most damningly, where they ignored the historical context provided by the military's own internal documentation. The testimony was so thorough, so scientifically rigorous, and so legally precise that the VA's representative, who was present at the hearing, was unable to mount an effective cross-examination. The VLJ was visibly affected by the clarity and depth of the evidence. This wasn't a standard boilerplate IMO. This was a comprehensive forensic analysis that made the VA's previous denials look medically negligent and procedurally dishonest. The impact was immediate. The VLJ, recognizing the overwhelming weight of the evidence and the severity of the procedural violation, the suppression of evidence, knew that a simple denial would be indefensible and almost certainly overturned on appeal to the Court of Appeals for Veterans Claims, CAVC. The expert testimony didn't just establish service connection, it established that the VA had actively undermined the claim for years, using flawed medical opinions to cover up their own failure to disclose critical documents. This was the moment of undeniable factual superiority that neutralized the VA's bureaucratic defenses. Following the devastating testimony, the VA faced a serious internal crisis, leading to the internal conflict, why certain VA employees tried to suppress the outcome. Once the BVA hearing concluded, it was clear to everyone involved that Sergeant M was going to win. The evidence was simply too strong, and the procedural violation too blatant. The internal conflict wasn't about the VLJ's decision, That was functionally determined, but about how to manage the fallout. The Office of General Counsel, OGC, and certain high-ranking officials within the Veterans Benefits Administration, VBA, recognized that a favorable decision for M, especially one that explicitly cited the suppression of internal memoranda, would create a devastating precedent. If this decision became public and citable, it would empower every veteran whose claim was denied due to the VA's alleged failure to disclose all documents in the C-file. This meant potentially reopening thousands of old denied claims. The conflict arose between the VLG, who was bound by law and conscience to issue a fair decision, and the administrative legal apparatus above them, which was concerned with institutional liability. Sources close to the case revealed a frantic internal debate. One faction argued for a prompt, clean decision, a victory for M, to mitigate further legal exposure and demonstrate good faith. The other, more powerful faction argued for administrative interference. They tried to lobby the VLJ to issue a non-precedential decision, meaning M would win his benefits, but the reasoning and findings regarding the CUE and the suppressed evidence would be sealed or heavily redacted, preventing other veterans from citing the case. They also attempted to convince M's team to accept a fast, favorable settlement in exchange for dropping the procedural arguments, effectively buying silence. M and his counsel refused, understanding that the value of this case extended far beyond his individual compensation. The internal pressure on the VLJ was immense, leading to a delay in the final decision even after the hearing. The VLJ resisted the suppression efforts, understanding that the integrity of the BVA process required transparency, especially when systemic misconduct was exposed. This internal struggle highlights the core tension within the VA, the mission to serve veterans versus the institutional imperative to manage financial risk and legal exposure. The fact that high-ranking officials were actively trying to minimize the legal impact of a just decision underscores the systemic resistance to accountability that veterans face daily. They weren't fighting Sergeant M anymore, they were fighting the principle of transparency itself. Finally, after months of internal wrangling and procedural delays, the BVA issued the final decision, breaking down the board's stunning reversal. The decision was not just a victory, it was a scathing indictment of the VA's handling of the case. The board, in a detailed multi-page analysis, granted service connection for Sergeant M's debilitating condition, but the most important part of the decision was the procedural ruling. The VLJ explicitly found that the initial rating decision contained clear and unmistakable error, CUE, because the VA had failed in its duty to assist by withholding relevant, favorable evidence, specifically the internal memoranda that documented institutional knowledge of M's post-service risk factors. This finding was a seismic event. A CUE finding is notoriously difficult to achieve, and one based on the VA's intentional suppression of evidence is almost unheard of. The decision stated clearly that the withheld documents were highly probative and directly relevant to the nexus determination, and that their omission rendered the original denial patently incorrect. Furthermore, the board gave significant, compelling weight to Dr. R's independent medical opinion, contrasting its thoroughness and reliance on the full historical record with the speculative and incomplete nature of the VA's negative C&P exams. The VLJ essentially threw out the VA's C&P findings, declaring them inadequate and unreliable in light of the suppressed evidence. The reversal was stunning because it wasn't a compromise, it was a total capitulation. Sergeant M was granted service connection retroactive to his original filing date decades ago, resulting in a substantial amount of retroactive pay and guaranteed future care. The decision was immediately circulated internally within the VA, prompting the flurry of attempts to minimize its public exposure. The VA did not appeal the decision. They couldn't, given the damning nature of the CUE finding and the irrefutable evidence of the suppressed documents. Their only recourse was to hope the decision remained buried deep within the BVA docket, uncited and unpublicized. The final decision was a legal mic drop, proving that tenacity, combined with strategic legal counsel and undeniable expert evidence, can shatter the VA's most entrenched defenses, even when they rely on active concealment to protect their interests. The true significance of this case lies in the legacy, how this case changes appeals for Montpestal veterans. This victory is not just about one veteran's successful claim. It is a powerful new tool for every veteran currently fighting the system. The successful QE argument based on the suppression of internal documents creates a vital precedent. First, it strengthens the argument that the VA's duty to assist is not just passive. It requires active, honest disclosure of all relevant material, including internal notes and memoranda that might be favorable to the veteran, even if the VA attempts to categorize them as internal working documents. This means veterans' advocates can now demand a more thorough, transparent review of the C-file index and challenge any missing or vaguely referenced documents, using Sergeant M's case as leverage. Second, the case sets a high bar for the quality of independent medical opinions. Dr. R's success demonstrates that IMOs must not just offer a counter-opinion, but must actively integrate and legally rebut the VA's existing evidence and procedures, turning a medical opinion into a legal weapon. Third, and perhaps most importantly, the exposure of the VA's delay tactics and internal suppression efforts provides a roadmap for veterans facing similar bureaucratic inertia. It validates the suspicion that the delays are often intentional, designed to exhaust the claimant, and empowers advocates to fight these delays aggressively, using motions to compel and requests for expedited review, citing the institutional history of obstruction revealed in this case. The VA's efforts to hide this success story stem from the fear that its widespread dissemination will lead to a flood of new CUE claims, forcing them to re-examine decades of denial based on incomplete or curated evidence. This case is a beacon proving that the system can be beaten, even when it fights dirty. It is a testament to the power of persistence and the necessity of demanding absolute transparency from the very bureaucracy established to serve those who sacrificed everything. So what does this mean for you right now, fighting your own appeal? It means you must stop relying solely on the VA's good faith. You must treat your C-file as a potential crime scene, meticulously searching for every missing piece, every redacted note, every internal memo that could be the hidden evidence the VA hopes you never find. Demand a complete, unredacted C-file, and if the index reveals discrepancies, file a formal discovery request. Understand that the VA's primary goal, often driven by financial constraints, is denial through attrition. Your job is to be the immovable force, armed with precise, legally defensible medical evidence that speaks directly to the VA's own procedural and medical failings. Sergeant M's victory, the one the VA desperately tried to minimize and obscure, is now your weapon. Use this knowledge to demand accountability, to refuse acceptance of vague denials, and to remind the VA that their duty is not to protect their budget, but to serve the veterans who earned these benefits. This case proves that the system can be forced to yield the truth, but only when you are prepared to fight, not just the medical opinion, but the bureaucratic machine itself. The fight is long, the resistance is real, but the precedent is set. The VA cannot hide the truth forever. Now go forth and arm yourself with the full unredacted story of this stunning systemic victory.